Well, the urgent bail application by one of the accused in the Senzo Meyiwa murder trial is expected to be heard later today. Bongani Ntanzi is one of only 5 accused with no criminal record or pending cases against him. The 32-year-old maintains he's being framed for the death of the former captain. But Tumelo Matlala, who was in the house on that fateful evening, identified Ntanzi as one of 2 intruders. Well, let's find out what is expected and the complications around this. eNCA's Silindelo Masikane.
Good morning, Gareth. Yes, we are outside the North Gauteng High Court where that urgent bail application for accused number 2, that is Bongani Ntanzi, is expected to be heard. We know that his lawyer, Titi Tobane, launched this bail application saying that there were exceptional circumstances in which could permit Ntanzi to be released on bail. We know that Ntanzi was arrested back in June of 2020. At the time, he was working in the mines in Rustenburg. He has alleged in court that, in fact, during his arrest, he was tortured by police to implicate his co-accused in this particular matter. And of course, we know that recently the state's 3rd witness, Tumelo Matlala, who was a close friend of Senzo Meyiwa, as well as one of those who was in the house on that fateful evening, has identified Ntanzi during a doc identification as one of the men who allegedly entered that home, which Meyiwa had pinned against the wall. But to just unpack the prospects of success for this bail application, we are joined by legal expert, that is Mr. Alton Hart from the UJ Law Clinic. Thank you so much for your time this morning, Mr. Hart. Maybe let's just start with these exceptional circumstances that may be put before the court. His personal circumstances weighed up against the doc identification. Just how much weight, Mr. Hart, can the court put on the doc identification, and exactly what kind of exceptional circumstances will Ntanzi have to show to the court?
Obviously, for me, doc identification, I don't put a lot of weight against it. Obviously, the state will now come and argue and say, but he has been identified as one of the accused who actually committed the alleged offense. But for me, doc identification, the weight that the magistrate or a judge should attach to it should be very little, because you only have so many people in that doc that you can point to. So for me, that is an important thing that the judge should not overlook. But when it comes to exceptional circumstances can differ from individual to individual. And one of the things that I just come up to my mind now is like, what is exceptional about Bongani Ntanzi is that he was never arrested, he was never convicted, and he doesn't have any pending cases except this one. That in itself, for a 32-year-old male in South Africa, is an exceptional circumstance. So that his lawyer Titi Tobane can focus on. Also that he is the sole breadwinner, for it's exceptional. For some families it will say, but that's a normal thing. But for him, with a high employment rate, you can play it in that way to say that is also an exceptional. And that is how the list can grow. So exceptional circumstances, there's not a closed list of what should be exceptional or what can be exceptional. You need to look at the person applying for bail and what is exceptional for that person. And that's how the court had to look at it. And it was recently also in the appellate division in State versus Fourie, where the court again highlighted these types of things, that you don't need to look at a specific set because you want to say, oh, this person is going to die and those type of things. No, you look at this particular person and what is peculiar to his circumstances, and you match it up with what is set out in section 60 subsection 4 of the CPA, as well as the subsections 5, 6, 7, 8, 9, 10 and 11.
Mr. Hart, maybe then let's just look at how the trial is unfolding here in the North Gauteng High Court. We know, of course, that there is a bit of a break right now in terms of the sitting. The next sitting is expected next month, in fact, in November, for about 3 weeks. And we are expecting that Tumelo Matlala will then be cross-examined by the defense. Just how important is it, I think, for the state then, for them to perhaps call somebody else in the house to corroborate Tumelo Matlala's story in terms of the 2 intruders and what happened on the night that Meyiwa was killed?
Obviously, if one looks at it, it would be in the state's interest if to call somebody else to come and corroborate. But I'm not dispelling or eliminating. The state can still find the accused guilty on a single witness version. The only thing is that the court should find that that witness is credible. And hence, for me, the thing is that what the defense lawyer should do is like they should work with the credibility of this witness to say that this witness is not credible. His evidence that he tended to court cannot be relied on. And then the state will have to call somebody else to come and corroborate. If the state relies on his evidence only, and they can get to a point where they dismantle his evidence to such an extent that the court makes a credibility finding against him that he's not credible in the evidence that he has given, then the state will have a serious problem. And already with docket 375 looming over the edge there in the background, that makes it a little bit tricky, because now suddenly in docket 375, Tumelo Madlala is now an accused person. And I think when the defense teams cross-examine him, then they must also knock onto that docket's door and say, listen, yeah, but you're an accused there. So will you not most probably say anything here to exonerate you so that you cannot be prosecuted in the other docket and play? And that's the legal battles and tactics that one needs to employ here. So for me, that is what I see currently unfolding. But I also saw that there was already on the forensic evidence, there was a little bit of damage to the state's case.
All right, thank you so much for your time this morning. That is legal expert Mr. Alton Hart from the UJ Law Clinic, just unpacking the proceedings that we're expecting to start at around 10 a.m. this morning here in the North Gauteng High Court, where, of course, Bongani Ntanzi will be applying for bail. And we will, of course, be applying as the media for access. And if we are granted, then we will be bringing you those visuals live here on eNCA DSTV 403.